Good morning, Myco Psycho. Good morning, Donald. Good morning, Mama. Good morning, Eric. I'm sure Rhonda's out there someplace. Who else we got? Who else? Tev? What's up, Tev? How's it going? It is Saturday morning, July the 5th. We just finished a 12-hour July 4th marathon about 12 hours ago. And now, we're back for another possibly 2.5 hours. Wait, what does this timer say? I don't even see the timer right now. I'm gonna check. I did that. It was 2 hours. I did that. That was probably the stupidest thing I've done all day. But anyway, pick that right back up where we left off, shall we? See, these are the types of things that happen 12 hours after you do a 12-hour marathon. You completely forget about things like tools on your computer, videos that are playing that are actually part of the presentation going out to the general public. I need a lot more coffee. Look, fortunately, I think ahead. Probably not enough, but I do. Ladies and gentlemen, I have put together some interesting videos from this past week. Most of the interesting stuff that I found, I'm not saying there wasn't other stuff out there, but a lot of the stuff that really caught my attention was in Judge Hesselink's. It was in Osaka. I can't say. No words. We're not doing words anymore. It was in Osaka County in Michigan someplace. Anyway, we're going there. Then we're going to go see Middleton. And then we're going to go see Simpson. Middleton had some pretty interesting things going on. And we're going to check in on that. And then Simpson, I had to put Simpson in because I like Simpson so much. And I thought his afternoon docket on Thursday was kind of funny. So that's where we are, ladies and gentlemen. I'm not necessarily phoning it in, but I am necessarily phoning it in. No, I'm not. We're going to watch these cases. We're going to enjoy them, or we're not going to enjoy them. Either way, it's going to happen. It's going to happen right now.
All right, the next matter is Jeff Hodges versus Megan Sheldon. It's file 25-40686-GC. Who do we have present for this case?
Jeff Hodges. Good afternoon, Your Honor. Matthew Kassar, P83663, here on behalf of the defendant, Megan Sheldon.
All right, thank you very much. And do we have, who's ready? Do we have anybody here for Jeff Hodges?
Yes, I'm here.
All right, I do see you now, Mr. Hodges. Thank you very much. This is a motion for summary disposition filed by the defense. I'm going to give each side an opportunity to tell me why they believe that their side should win. Counsel, go ahead.
Your Honor, just so I can clarify, I think today, I'm happy to go forward. We did file, Ms. Sheldon filed a motion for summary disposition. It is set for hearing July 14th. Just to comply with the court rules, the 21 days. This was the date and time set for a pre-trial. Again, happy to go forward with arguing the motion for summary disposition, but per the court rules, we had to set the hearing out 21 days.
I see that now. Thank you for bringing that to my attention. Mr. Hodges, did you understand what he just said?
I don't know the procedure.
The procedure is if they file a motion such as he's filed called a motion for summary disposition, that is a motion that says we win by virtue of what the law says, they have to give you 21 days to respond to that. And that would be on July 14th. It's already set for a hearing then. So 2 weeks from now. However, if you want to, you could allow that to be heard today and we would just cancel the hearing on July the 14th. If not, we'll probably just come back on July the 14th and we'll argue it then. What would you like to do, today or on July 14th?
I prefer to see what can be solved or not solved today.
Okay, so you want to go forward today and,
yes,
and not have the hearing on the 14th, is that correct?
Yes.
Okay, all right. So I'm going to give both of you again an opportunity to argue your sides and to put out whatever information you want me to have. So counsel, this is your opportunity. Go ahead.
Yeah, thank you, Your Honor. This is, I trust that the court received the briefs and the motion. This is one of several actions filed by Mr. Hodges in the wake of his termination as a contract worker, ultimately for the end client Wade Trim Inc., which is a professional engineering firm. Mr. Hodges filed several actions that we believe are frivolous. This is one against Mrs. Sheldon, who was a remote supervisor of Mr. Hodges during his 3 or so weeks as a contract worker. Mr. Hodges was terminated for performance purposes, performance concerns. He was an at-will employee. He was actually terminated from it's called Act Talent, which is a staffing agency that Wade Trim uses to staff some of its engineering projects. This was filed initially as a small claims matter. There's a short affidavit with uh, half a paragraph or so of allegations that are vague, conclusory, do not state a cause of action, and do not state any facts that would support any cause of action under Michigan law. So Ms. Sheldon moves under MCR 2.116C8 and 10. Mr. Hodges' claim, if there is a claim, if there is a cause of action, fails as a matter of law for all these reasons. There's an affidavit from Ms. Sheldon in support of the motion for summary disposition. And I will note, Your Honor, that because Mr. Hodges has not responded, um, ordinarily, in order to defeat a motion for summary disposition, you would need to respond with an affidavit or evidence of his own to rebut the arguments that are stated in our motion for summary disposition. That hasn't been done. Again, I'm not sure that there would be any reason to do that because, again, there's no cause of action. What it suggests is a wrongful discharge, but he was an at-will employee, not even an employee of Wade Trim. He was a contractor, and at-will employees can be terminated at any time for any reason or no reason. We go into our briefs, and I'll just be brief, no pun intended, but be brief. If there was a cause of action for fraud, that hasn't been pled because all the elements have not been established. If there's a cause of action for intentional infliction of emotional distress, that too fails under Michigan law. And if there was a cause of action for wrongful discharge, as I stated again, under Michigan law, that's not viable. For these reasons, we request that the court dismiss this case. And that's it. Yep.
All right. Mr. Hodges, how do you want to respond?
First, I'm aware of the at-will law, but my termination is illegal because I'm a protected employee under the federal laws, and I clearly state so. Seems like the other end has problems of the comprehension, so that's problem one. So I filed a small claim lawsuit against Megan Sheridan for her deceptive action to lie to me for a meeting 2 hours away to drive that incurred significant travel expenses on the last day of the snowstorm here in Michigan. And potentially criminal activities has occurred because after I was unwilling to settle initially, someone in Wade Trim made a false accusation on me, accusing me as a terrorist, trying to get me arrested. And the police report is available in Kent County Sheriff Office. And the CFS number is KSP-0123167-2025. But of course, the prosecutor see the content is nonsense, so they decline to press the charge. And through this process of the bogus, baseless attack to fabricate me as the terrorist, online stalking has occurred. So as an additional discouragement of further actions like that, because someone in Wade Trim stalked me online, collecting information, and that includes the CEO of the Wade Trim. So I have to file additional lawsuits to the CEO directly himself to discourage future escalation of the harmful activities against me.
Your Honor, may I respond?
Sure.
So I want to respond to each point made. First, Mr. Hodges, one, did not plead that he's a protected class, and two, there's no evidence obviously offered that he would be a protected class. There's nothing that would suggest that he was anything other than an at-will employee. Also not an at-will employee of Wade Trim or Ms. Sheldon, who's the defendant in this case, which was just one of his remote supervisors. Two, he said he incurred travel expenses on the day that he was terminated. If he did, he was reimbursed for everything, and these proofs are in our papers, so that allegation does not hold any water. And three, the quote-unquote accusation of Mr. Hodges as a terrorist is not true. If you look at, I believe it's Exhibit to the Ms. Sheldon affidavit. Exhibit A to Ms. Sheldon's affidavit is a compilation that Wade Trim's Human Resources Department collected of Mr. Hodges' public LinkedIn comments that indicate that he is notorious for filing lawsuits and also has several threatening and violent comments against employers and supervisors and the like, which is why Mr. Hodges was reported to local law enforcement as Wade Trim's Human Resources Department was concerned for the safety of their employees. And as he mentioned, filing a lawsuit against the CEO, that is also a lawsuit pending before Your Honor, and we have also filed a motion for summary disposition in that case and seeking sanctions for filing frivolous cases against Wade Trim and its employees. That lawsuit obviously is not up for today. It's coming for hearing on July 21st, but we will be seeking the same dismissal and also costs and fees in order to have to defend against that case. In addition, Mr. Hodges filed a petition for a personal protective order against Mr. Andrew McCune, who's the president and chief executive officer of Wade Trim. This is also a frivolous filing, also requiring Wade Trim, Mr. McCune, and Ms. Sheldon to incur legal fees by way of a frivolous lawsuit. Again, there's no cause of action here. There's no facts that would support a cause of action, and it requires, and there's no evidence to rebut the now unrebutted evidence attached to our briefs that establishes that summary disposition in favor of Ms. Sheldon is proper.
All right. Mr. Hodges, what information do you have to support your claim that you are a protected individual under federal law?
In the email communication, I told, who was it, Megan Sheridan, that I'm a protected employee. And due to the underlying reasons for the protection, I need the reasons to notify them. And because of the email correspondence, since April, I was terminated because of this. And
I still haven't heard you tell me why you're a protected individual. What status do you have that would allow you to be protected under federal law?
I'm protected under American Disability Act due to various disability conditions. Thus, I have
such as what?
Where such as this. So I need.
Have you submitted any of that documentation with your responses to this court so that I can determine whether or not you're a person that has a disability?
How should I submit the information?
You do it the same way you sent in information on anything. You filed a complaint with this court. That's when you put in. That's how you put in the information. You drop it off at the court or you mail it. However you got the original information here, that's how you get that here. So okay. Have you submitted any documentation to support your disability claim?
They are here on my side, but not on your side yet.
Well, there's nothing I can do about it. You haven't submitted it. You haven't sent it into the other attorney. You haven't sent it into the court. So there's nothing that I can look at to determine whether or not you actually have a disability claim there. Just showing me a pill bottle and papers doesn't do any good at all.
Given that situation, I do have some additional information here. I don't know how visible this is.
It's almost invisible. I can't tell what it is at all.
Okay, fair. Then I will not try that. Is there a way to request a hearing at a later date after I submit the information related to this?
Well, tell me what that information is going to be, and I'll make a decision about that. So, what is your claim for disability?
Because I informed them that I have underlying disability falling under ADA. And
that's a conclusion. That's a conclusion, sir. I don't want a conclusion. I want you to tell me what facts you have that prove that you have a disability of some kind.
Okay.
You have a doctor. Do you have a doctor telling you that you have a disability?
Yes, I do.
And the doctor says that you can't work, or that you have limitations or restrictions on your work.
Yes, And as a result,
Who is that doctor and what are the limitations or restrictions?
I need accommodations in the hours so I can attend to the necessary medical appointments I need.
Who is the doctor and what are the limitations?
Where my psychiatrists like Angela Schutte, the psych nurse, and my psychological therapist, Daniel Shepard, and I need additional psychological evaluation to make further determination of the condition to make better treatment.
Then you don't have a disability if you need further confirmation of that. That you might want to go for a disability, but you don't have one right now. Do you have a disability from a doctor that says that you cannot work or you can only work with limitations?
I have that.
Where?
The disability is established, and it was diagnosed of me as early as 2018. And that's the record I always have. And that's the record I always inform the employers that I have a disability and I need accommodation.
So that's step number one. So I'll keep that in the back of my mind for a minute to determine whether or not we need to have a further hearing on your disability. The next step is, even if you had a disability, how is Ms. Sheldon the one who fired you?
Where I told her I have a disability and I have to let everyone know I have a disability so the hours can be accommodated. And upon telling her so, I was terminated as a result.
Who were you working for?
I was working for Trim.
The defense has said that you were working for a temporary firm by the name of, was it Activent?
Yeah, where I was working for Trim through firm, yes.
You might have been working at a Wade Trim job site,
yes.
But what evidence did you have to prove that you were working for Wade Trim?
Where the payroll comes from the firm that is excellent, but I reported directly to Megan Sheldon.
I'm not asking who you report to. I'm asking who hired you.
Excellent.
Ms. Sheldon worked for Actilent?
I don't know who she works for. Probably with Trim or wherever the payroll comes from her.
Well, the defense has said that she works for Wade Trim and not Actilent. So if you work for Actilent, why should you be suing Ms. Sheldon?
Because Mr. Sheldon is the one conducted deceptive actions on me and terminated me.
She didn't terminate you if she didn't employ you.
Then I don't know how that works.
I'm sorry that you don't, but all I can tell you is you can't sue somebody for doing something that they can't do. If Ms. Sheldon is not your employer, she can't fire you. Your employer fired you. Your employer right now is Actilent, as far as I can tell.
Then they never fired me. They did not say they fired me. They just want to stay away from this problem, and they told me they didn't do anything until it gets pretty chaotic.
Then what's the problem? Why should I have a lawsuit against Ms. Sheldon if you were simply told to stay away? You're employed by Actilent. They can tell you to go wherever you want. They want you to go, can't they?
No, so that's why I received the COBRA letter, so that shows that the termination of the employment. Then because Megan Sheldon did the decision of termination, so
how can Megan Sheldon make a decision to terminate you if she doesn't work for Actilent?
I don't know. The termination decision comes from her in my perception.
Your perception doesn't mean a thing right now if she doesn't work for Actilent. You've told me that you were employed by Actilent. The defense tells me that she's employed by Wade Trim. You don't have any, do you have any evidence to dispute that?
I don't.
Okay, then based on that information, then it really doesn't matter whether you've got a disability or not. Your lawsuits against Megan Sheldon, there's nothing that she did or could have done that would be viable in a lawsuit if it's a termination of employment process. That's all through Actilent. You're going to have to sue Actilent. Megan Sheldon's got nothing to do that. Counsel, did you submit a proposed order in this case yet?
Oh, we did not, Your Honor. We can submit one today, though.
All right, please do so, indicating that I find for the defense for the reasons stated on the record, and I'll sign that once it's submitted here. Thank you very much. All right, that's all
Yes,
for
Your Honor.
today.
Thank you.
All right, the first matter up for the docket in district court is State of Michigan versus Michael Jones. There are two files for that. First is 25-X4492224-SI and then 25-X4492224A-SI set for a formal hearing. I do believe Trooper Kennedy is with us. Do we have Mr. Jones with us? All right, I do see Michael Jones with us. Trooper Hubbard is with us as well as Trooper Kennedy. All right, this is a ticket back in February of this year involving careless driving and no proof of insurance. Looks like there was an original default in the matter. Mr. Jones requested that that be set aside, and the court did so. I believe we had one other court hearing in which there was some technical issue with the court's Zoom. Mr. Jones was present, but the court couldn't see him, so the case was defaulted at that time. We've undone that as well, so we've had some procedural hiccups, but we are here today on a formal hearing. I would ask Mr. Jones, Trooper Hubbard, and Trooper Kennedy to raise their hands so I can swear you all in at the same time. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right.
I do.
I'm going to have the officers go first, and then Mr. Jones, you'll have an opportunity to ask questions or cross-examine them. And then Mr. Jones, if you wish to make any statements, you'll be allowed to do that, and the troopers will be able to ask any questions that they wish at will. Which of the officers wishes to go first?
Judge, because it's a formal hearing, did you want me to lead the questioning or did you just want
I'm
them?
sorry. I apologize, Ms. Brucker. Please go right ahead. I jumped into my prosecutor mode there and I should not have. I apologize. So please go ahead, Ms. Brucker. You determine how you want to present this case.
Okay, Judge, I would call Trooper Hubbard first.
All right, thank you very much. Trooper Hubbard, you are sworn. Ms. Brucker, you may begin.
Trooper Hubbard, could you state your name for the record and spell your last name?
Yes, my name is Jacob Hubbard, last name of Hubbard.
Your occupation and where are you employed?
Currently, I'm a sergeant with the state police, Alpena Post.
And did you hold a position with the state police prior to that?
I did. I worked as a
And what-
trooper at the Gaylor Post.
And how long did you hold that position?
I've been employed for almost 9 years, and I was a trooper for most of that time until recently in March of 2025.
Okay. Were you on duty on February 9th of 2025?
I was.
And did you travel down Old 27 South on that date while you were on duty?
I did.
Could you describe what the road conditions and weather conditions were on that date?
Absolutely. On 2/9/25 at approximately 10:55 in the morning, I was traveling southbound Old US 27 after responding to a rollover crash on the freeway on I-75. Road conditions, it was one of those snowy weekends. The roads were completely covered with snow. It was currently snowing at that time as well.
No, I'm
I'm sorry, Mr. Jones, did you say something? You're on mute now, Mr. Jones. Did you say something, Mr. Jones?
yeah, I don't guess I meant to, but it wasn't snowing. It was snow-covered roads, but it was.
All right, Mr. Jones, this is not how the court works. You don't get to interject whenever you want. This is their time to ask questions. If you have an objection,
I apologize.
if you have hang on, you need to listen to me first. If you have an objection, you may say, I object, and tell me what that is. But if you simply disagree with what he's saying, you're going to have a chance to ask him questions, and you're also going to have a chance to testify later. So you don't get to say, I don't like that. If you have a legal objection, you may state that. You may say, I object, and there's a legal reason why, and here it is. And then we'll move forward. All right, go ahead, Ms. Brucker.
Right. Just to let you finish that thought, Trooper Hubbard, were the roads covered in snow on that date?
Yes, they were. They were very snow covered, and it was snowing outside.
Okay. Had you responded to other incidents that date involving vehicles sliding off the road?
We did. In fact, that's what there was about three patrol cars returning back to Gaylord after responding to a rollover crash on the freeway due to the weather and road conditions.
Okay. And what other patrol were you, the three of you traveling down Old 27 together?
Absolutely. So to set the scene, there was me. Directly in front of me was a maroon in color F-150, which belonged to Mr. Jones. Later found out. In front of him was Conservation Officer Cherry, driving his marked DNR patrol truck. And then behind me was Trooper Kennedy and Trooper Duff inside of their own state police patrol car.
Okay. And did something draw your attention to that maroon vehicle?
It did. So while southbound, we were past the auction building there right by Metelsky Road, and there's a passing lane there, which on a normal day wouldn't be an issue. But due to the weather conditions, I thought it was odd when that maroon F-150 started to pass the DNR truck on that passing stretch. When that vehicle started passing, it started kicking up snow, made it difficult to see both the F-150 and the DNR truck. I will admit, what looked like the pass was completed within the passing zone. And I know after speaking with Conservation Officer Cherry, it was completed within that zone. However, it was learned that Officer Cherry was going approximately 53 miles per hour, and the F-150 clearly passed him, signifying they had to go faster than 55 miles an hour to pass him on the weather conditions of that day.
Okay. And what is the speed limit on that stretch of road?
It's 55, ma'am.
Okay. And just to be clear, this is in Otsego County.
Yeah, I believe it's just into Livingston Township.
And after that vehicle passed, what did you do next?
At that point, Conservation Officer Cherry pulled over, and I activated my lights, and I went in an effort to catch up to the vehicle. Due to that stretch of roadway, I don't know how familiar the court is. After the passing lanes end, it immediately goes into the S curves. The first one will bank to the southeast. Again, due to the road conditions and weather conditions, with my lights fully on, I was unable to catch up to the vehicle as I went through the S curves, passed down Ironton Springs, and finally was able to catch up to the vehicle once we both passed Parmenter Road, and I activated my siren to get the attention of the vehicle ahead of me.
And did you note what your speed was as you were attempting to catch up to that vehicle?
Yeah, so when you get through the first S curves and it comes to Ironton Spring, there is a straightaway. At that point, I tried to catch up, pushing it, I might add, to about 67 miles per hour, and I was still having a hard time catching the vehicle. I wasn't ever able to even get a good radar reading on the vehicle due to the weather and the constant curvature and the distance between me and the vehicle. It was hard to get the vehicle in my operational beam of my radar until the straightaway, and I had the F-150 at 56 miles per hour as it was entering the next curve just after Ironton Springs.
Okay. But based on your observations, you believe that it may have been going faster than 56 miles an hour at some point?
Yes. Due to how long it took me to catch up to the vehicle, I have no doubt that the vehicle was going faster than 56 miles per hour.
I object.
Okay.
What's your objection, Mr. Jones?
The whole thing is fabricated from what my opinion so far, Your Honor.
All right, Mr. Jones, I don't need your opinion right now. I need to know what your legal objection is. So what's your legal objection?
My legal objection is the officer already had lied, and he already said he wasn't going to lie, right?
All right, Mr. Jones, credibility is credibility is for me to determine. I need to know what your legal objection is.
He told me that he called when he pulled me over. I said, "Are you serious?" And he was trying to provoke.
Mr. Jones,
bro,
this is not our time for argument. I need to know what is your legal basis for your objection.
He told me that he called the guy and he said he was doing 56. I said horse crap. I said he never made
Mr. Jones.
Power. I'm telling you the truth, bro.
Mr. Jones.
Yes, sir.
You're either going to do this my way or you're not going to do it at all.
Hey, I get it.
This goes in a proper procedure. You get to say you object. Not because you don't like what he's saying, but because there's a legal reason for it. I've not heard a legal reason for it yet. Do you have a legal basis for your objection?
I just know facts are stubborn things.
That's not what we're talking about then. If you disagree with the fact, Mr. Jones, keep your mouth quiet for a minute so I can talk. If you disagree with what he's saying, You're going to have an opportunity to tell me that. Now is not that time. Work with me here, sir, so we can get through this in a proper way. All right, Ms. Brucker, you may continue.
Okay. Trooper Hubbard, did you conduct a traffic stop of that particular vehicle?
I did. As I said, I was unable to get the attention of the vehicle ahead of me. It wasn't until we got close to Parmenter, I activated my siren to get the attention, and just past Parmenter, finally the F-150 pulled over and I performed a traffic stop there.
And did you make contact with the driver?
I did. So I made contact with Mr. Jones. It was very apparent right away that he was irritated and disagreed with the reason for the stop. He told me that the vehicle in front of him, he didn't realize it was a DNR truck, and that he believed the truck in front of him was going back and forth between 40 and 50 miles per hour. So he decided to pass him in the passing zone. He also had some issues said he was late and had some things break down. He was going to a shop to try to get a hydraulic hose fixed or something of that nature.
Okay. Did he provide you insurance and registration paperwork?
Slowly. Mr. Jones was extremely hostile during that time. I had to ask him for his paperwork, which he was continually asking me how long this was going to take, and until he finally gave me the paperwork. Then when I went back to the car to look at all this paperwork, he proceeded to get out of his car to confront us. By that time, Trooper Kennedy and Trooper Duff were on scene in an effort to confront us about the reason that he disagreed with the whole stop and how long it was taking. After he was ordered back into his car, or the truck, I would add, I then started looking at his paperwork. I realized he gave me an expired proof of insurance, which expired on December 8th of 2024. I went back up, asked him for a new proof of insurance, which he was unable to provide me. At that time, I went back to the patrol car and issued a citation for careless driving and no proof of insurance. If I may also add, I know Mr. Jones is going to have an issue with the way I parked my patrol car that day. And the reason why I park it on an angle pointing towards the ditch. It's an effort to protect my backside from traffic coming that way. And I always park a little bit into the lane in order to do that. So I want to get ahead of that argument as well, because I know while on scene, he had an issue with that as well.
Okay. Trooper Hubbard, just to be clear, why did you issue him the citation for careless driving?
Due to the couple of reasons. So we've been responding to crashes that day with the weather, with the way the roads were. The way I had to drive to catch up to him was extremely unsafe and put everybody further at risk. Again, I'll admit that he passed within the passing zone and was able to complete it, but that was definitely operated in a careless manner that was at least negligent to everybody else on the public roadway, because it's not needed, especially because the conservation officer was going 53 miles an hour and he would needed to pass him at a higher rate of speed. And then the fact that it took me so long to catch him, he either couldn't see me because of the weather or he didn't want to. So I don't know which one's better, but I don't know other rationale why he didn't stop for the roughly 2 miles I was behind him.
And you had your sirens in your patrol vehicle activated during that time?
I had just my lights on from the passing lane all the way to about Parmenter. It wasn't until then I've had to activate my sirens to finally get the attention.
Okay. Were there any visibility issues that day that prevented him from seeing those lights?
Yeah, I would say so, because when you're driving on those roads, it would kick up snow behind you. So I don't know if he wasn't able to see me because of that. I don't know.
All right. Is there anything else you'd like to inform the court of regarding the traffic stop?
No, there's not.
Okay. Judge, I don't have any other questions for Trooper Hubbard.
All right, Mr. Jones, do you have any questions for this witness?
I just hope he gets some new training on how to
Mr. Jones, do you have questions?
Yeah, I do have a question for him. If I
Please
was
go ahead and ask your question then.
if according to this gentleman's testimony, if I was so careless when I passed the CO officer, why didn't he pull me over?
Mr. Jones, do you have a question for this witness? Not a rhetorical argument.
Well, I try to stick to the facts, sir. And look, there was an accident on 75. I get that. I looked at the guy and nodded at him. I could have taken him right out of Vanderbilt headed south.
Mr. Jones, this is not the time for your argument. Do you have a question for this witness?
No, I just would hope he would get some further training on.
Mr. Jones, I don't need your extemporaneous comments. I need to know if you have a question for the witness.
No question.
Next witness, Ms. Brooker.
Judge, I have three other officers here, Trooper Kennedy, Trooper Duff, and Conservation Officer Cherry. I wondered if it'd be okay with the court if I just collectively ask the three of them whether there's any additional information aside from what Trooper Hubbard already testified to that they could provide, and if not, we can move on. I just want to expedite this.
Please feel free.
Okay, so Trooper Kennedy, Trooper Duff, Conservation Officer Cherry, do any of you have any additional information regarding this traffic stop that Trooper Hubbard did not already cover in his testimony?
I do not, ma'am.
Okay.
I do not have anything to add further.
Okay. Okay.
No, ma'am. I just would agree with Trooper Hubbard with everything that he said strongly.
Okay. Judge, I don't think I need to question them further. I think it'll be repetitive as to what's already been placed on the record.
All right. Mr. Jones, you now have the opportunity to make a factual statement, that is to testify, and then you would be subject to cross-examination after that. So, Mr. Jones, this is your opportunity to tell me what happened that day. Go ahead, sir.
Well, right from the beginning, how it all started. I was plowing. I was hosting my mother-in-law's 95th birthday party, and I had to make a few passes. I caught a log, blew a hose. I called my usual guys. They're not open. I started to panic because I had a big party for my mother-in-law. I got a hold of a guy. He said that he could make it if I had it. I already had it off. So I already had my truck started. I pulled up over 75. There's an accident on 75. As I roll across 75, two state troopers are coming up the exit ramp on the northbound lane. I literally looked at Trooper Hubbard and nodded at him as I saw him, right? As I pull out and go through town, the truck in front of me, I had no idea was a CO officer, right? He's doing about 30 mile an hour through town. It's 35. As you head southbound out of Vanderbilt on 27, it goes from the village limit 35 to 55. Now, right there, I could have just took him right there, but I didn't want to be aggressive. I've got two state troopers behind me. I know the law, sir. So I'm driving, and there's a coin flip. There's a vehicle. I thought the guy was going to get going. He maintained 42 to almost 50 miles an hour. He got to 50 almost twice. And each time there was a vehicle coming, or it was a coin flip of whether this would be too aggressive. Now, when the officer referred to the Gaylord Auto Auction and Metelsky Road, I knew that was a passing lane there. And so I'm not trying to ride them because you could clearly sneak, but the roads were snow covered. And I understand about people aren't comfortable driving. My whole career has been driving. Okay. So as soon as I could see the intersection of Metelsky and there was no vehicles, I turned my turn signal on, made the pass, and immediately I see the officer hit his lights and make the same pass. Now, I don't have any idea what he's doing. I'm doing 55 miles an hour now. Okay. So I'm going 55 miles an hour all the way through. Okay. Once I got southbound of Parmenter Road, I saw him, but I'm like, it's not my duty to know. If I'm an officer and I'm going to pull somebody over at 55, I'm going to pull them over. I don't agree with what he said about whatever, as far as driving conditions. It was not snowing. If it was snow, it's real light, but you could see for a long ways. And I wasn't going to try to make a stupid move with two cops behind me, Your Honor. So when I made the legal pass, and then I couldn't believe that he turned his lights on, I said, well, he's not coming after me. And then as soon as I passed Parmenter Road, and then he started to gain a little bit, that's when I turned my signal on and yielded over. To which he came up and said, I said, what's up? He goes, yeah, what's up? And he said, you passed the CO off. In fact, when I passed the CO officer that I didn't know was the CO, I looked right at him and nodded at him as well when I made the pass, Your Honor. Now, I'm not trying to be aggressive or ignorant on the road, and I understand conditions. So when he said, you passed the CO officer, I said, so what? Is there a law against that? Right? I didn't ask him that. I said, so what? And as soon as I said that, he said, well, you passed on a curb. And I said, horse crap. And then he looks up and down and starts going, Well, it's okay to be mad. I don't care if you're mad. It's okay. He was trying to provoke something, Your Honor. And I just stayed there going, and I'm saying, dude, it's my mother-in-law's thing. I've got stuff to do. Are you serious? You're messing with me for what did I do? I didn't do anything wrong. Now, as far as the insurance goes, my birthday was a week before that. So I usually have the cartoon copy, which my wife sent me that copy right there. And I know about the law enforcement information network. You can clearly see whether it's in current or outstanding just by looking at the tabs. I upset him when I said, so what? And he knew I was upset and it got provoked. And as far as me getting out of my vehicle, I was sitting there like 10 or 15 minutes. And that's when I was like, because as far as the cops behind them, they pulled right up behind them, the cop and the CO. There was only 2 officers and the CO that I saw. But after 10, 15 minutes, and I thought, well, I don't know if these guys were playing a game of is this guy going to pull over or not? I don't know what these guys are doing. But then the way he went about that, as far as, I don't care if you're mad. It's okay to be mad. It's okay to be mad. I don't care if you're mad. He said that a dozen, 20 times, baby. I don't know. I don't remember exactly, but I know I went through this over and over. Like, what the heck did I do? Is it this? I didn't do anything wrong. In fact, lack of attention or caution likely to endanger person or property is how the careless law is stated, which there was no harm. There was no foul. I made a legal pass. He didn't like my answers, so he was going to teach me a lesson. And when I got out of the truck to go, come on, the CO, I don't know what he did, but he pulled something on his side, demanded me to get back in the truck. So then I was like, to which I stated, you clowns watch too much TV. And then I got in the truck. So maybe that hurt his feelings too. So I guess freedom of speech isn't in the Constitution, according to Trooper Hubbard, Your Honor. Because he clearly had he didn't like my attitude, which was, I didn't do anything wrong, bro. I didn't do anything wrong. So he knew I had the insurance. He cited me a ticket for that, to which when I denied responsibility and initially requested the informal hearing, evidently that was mailed from you guys, I never received it. I wouldn't, Your Honor, I wouldn't request an informal hearing and then not show up for it. That's not, God didn't make me that way. So whatever happened there, it was totally, so then I had to go and refile, to which the lady.
Mr. Jones, we're not here on the procedural issues. I already put that on the record to begin with, and that's not being held against you. So I don't need you to argue about the procedural issues. I just need to know about the facts of the case, sir.
Well, that was pretty much it. And then, and to which I like to understand if it was such a careless act on my legal pass that I made. When he called it, when I said, "Are you serious?" He said he called the CO, and the CO said he was doing 56. To which I said, horse crap again. I said, you guys were behind me. We never made it to 50 mile an hour till I passed him, and a legal passing zone. So in my opinion, it was fabricated. He didn't like my answers, and he was teaching me a lesson.
Anything else that you want to say, Mr. Jones?
No, sir. That about sums it up.
All right. Ms. Brooker, any questions for this witness?
No, Judge.
All right, Mr. Jones, do you have any other evidence that you wish to present?
My evidence is my word, Your Honor. I was not exceeding this. If I did exceed the limit, it was 1 over maybe, because that's what he said. He said he was doing 56. I said I might have made it to 56 by passive. I said no way. I said he never went to 50. He never made it to 50 miles an hour, and they were behind me. So, and I do have insurance, so I don't know why that. I think it was just one of them deals.
All right, Mr. Jones, I do have a question for you. I didn't understand what you were trying to tell me when you talked about the no insurance. You said that you had insurance, that your birthday was a week before. Now, the question is whether you presented the officer with proper proof of your insurance. Did you do that?
I gave him the copy that I had, and to which I noticed it was expired the prior week, to which I usually have the hard cartoon copy in the truck. And my wife texted it to me. I have it on my phone. Did you show that? Did you show your phone to the police officer? Oh, he did. When he came up and said he was citing me for no insurance, and careless driving, I pretty much was like, I couldn't believe what was going on. It was like modern day extortion, in my opinion. Just us, not justice. That's my opinion here.
So the answer, Mr. Jones, is that you did not show the officer that you had proof of insurance that day. Is that what you're telling me?
Well, yes, that's what I'm telling you, but I haven't. I had it on my phone, to which there was no chance to, when my wife, I texted my wife and asked her, and she said, "Oh, I thought it was in there." She took a picture of it, texted it to me. And then at that point, he'd already issued me 2 citations. And I mean, you know what? When he handed me that tickets and started trying to explain it to me, maybe he could have pulled me over then, because I did take off out of there like, what is this? What's going on? And he held me up for like, I don't know, 30 minutes at least. 25, 30 minutes, I'm going to say. Anyways, that's no big deal.
All right, Ms. Brooker, any closing arguments?
We would just ask the court to find Mr. Jones responsible for both of these citations based upon Trooper Hubbard's testimony that at the time he passed Conservation Officer Cherry was going around 53 miles an hour, and Trooper Hubbard had to get up to around 67 miles an hour in order to catch Mr. Jones in order to perform the traffic stop, also taking into account the road conditions and even Mr. Jones' own testimony that he saw Trooper Hubbard operate his lights of his vehicle almost immediately after he passed Conservation Officer Cherry, but it took him still a ways to stop his vehicle. So I believe there's ample evidence for the court to find him responsible in both of these. Obviously, he just made some admissions regarding the no proof of insurance, so I don't think I need to do any additional argument on that.
All right, Mr. Jones, this is your opportunity to argue to me now why you believe that you're not responsible for either of these tickets.
Well, Your Honor, my insurance was current. The officer has a system. I mean, it's an imperfect world. I'm not trying to explain anything to you. And as far as careless, Your Honor, I made a legal pass in a legal passing zone. I understand some people, they're not comfortable driving. I drove my whole career. I drove weather, snowing, blizzard, hot. I understand. I went through things. I know how to drive. My record is immaculate. So as far as this guy's opinion, I disagree with their opinion. I mean, and he's not showing you facts, Your Honor. He's telling you his story. He's not showing you facts. He's telling you his story. That's the truth. Because I like I said, the truck in front of me never made it to 50 miles an hour. And when he said he called him, he said he was doing 56. To which I said horse crap again, right to him. I know he didn't like my attitude, Your Honor, but I didn't do anything wrong. This guy didn't get any action. I didn't know if they had a bet going. Honestly, this guy hit the accelerator 42 to 50. 42 to 50. What are you trying to? I don't know what was going on. Finally, when it was open, clear, and not aggressive, I made a legal pass. Then he turns his lights on. Why didn't he come after me? He's trying to figure out what's going on. Is it protocol for him to call the CO and for him to say, "Oh, I was doing 56." Now he's saying he did 53 because he told me 56 that day. To which I said, "No way." Actually, I said horse crap again because I said, "Dude, he never made it to 50. You guys were behind. Why would I purposely do something?" And there was no harm, no foul. There was nobody on the road when I made the pass. This guy, they were looking. They didn't get any action on the 75 southbound that was backed up north of Vanderbilt. I don't know, sir. That's my opinion, and it seemed to me like it was time to railroad this guy because they didn't get any action over there. I hate to put it that way, but pretty much how it went down.
Anything else, Mr. Jones?
Oh, sir.
All right, the two matters in front of me involve careless driving, which is by statute, driving in a careless or negligent manner likely to endanger any person or property, but without wantonness or recklessness, and then no proof of insurance. It's not the more serious charge of not having insurance. It is failing to provide proof of insurance. By the defendant's own admissions, he did not present proper proof of insurance to the police officer upon request. Mr. Jones testifies that he had proof of insurance on his phone, but that he did not present that to the officer. And for that reason, I'm going to find him responsible for the no proof of insurance. That's $160 that will be owed to the court as a result of that. On the careless driving ticket, the issue is before the court is not whether there was a proper pass. The issue before the court is not whether there was speeding, although those two things can contribute to careless or negligent driving. And the fact that there wasn't speeding or that there was a proper pass does not stop the court from finding that there was careless or negligent driving. It is based on all of the facts and circumstances at that time. If the road conditions don't support a legal passing speed, then the road conditions dictate whether or not it is careless or negligent to drive at a speed, even if it's within the legal speed for the roadway. If we're having a blizzard, and again, I'm not saying that's what happened here, but if we're having a blizzard, speed has to be reduced because of the visibility and the slipperiness of the roadway. That is the basic speed law. You may only drive at which the conditions support the driving. In the testimony, not only of the trooper that testified mainly, but of the other three officers who joined in their opinions, in all of their opinions, it was their opinion that it was too fast for conditions. In other words, it was careless to pass under the circumstances on the roadway. Mr. Jones disagrees with that opinion, and it would be so much easier for this court to find on behalf of Mr. Jones if his attitude were not so ridiculously poor. Mr. Jones assumes the worst in all of the other officers. His opinion is that they did certain things, and he attributes poor police behavior based on his own not wanting to be found responsible for a ticket. Mr. Jones, if you want to be taken seriously, you must act in a serious manner. None of the officers in this case have given me any reason to disbelieve their testimony. I agree with you that under normal circumstances, what you did was not illegal. There is no problem with passing in a passing zone. There is no problem with going, even if you slightly went over the speed limit to get past a driver who was doing 53 miles an hour. I would not normally hold you responsible for that. Okay, but under the circumstances of that day and that time, where the officers had just gotten off of I-75 for an accident, okay, and they were well aware of the slippery road conditions and the snow on the road and the snow coming down on the road, and then you pass directly in front of them, they had no other alternative but to stop you. And quite frankly, your attitude just made it that much easier to give you a ticket. And it makes it that much harder for me to believe you. You have the right to say in America whatever you want to say.
Right.
But that does not mean that the police or the court need to believe you when you say those things. And so you have given me every reason to discredit your testimony because of your attitude. Okay, so I'm not saying that you don't have the right to say the things that you want to say. You absolutely do. But I also have the right to not believe you because of the things that you say and the way that you present yourself. So I believe that the police officer's testimony gives me the ability to find you responsible for careless driving, and that's what I'm going to do.
Yeah, I've already paid.
No, you're done. This is not your time to talk, Mr. Jones. This is my time.
I got it.
Your time is done.
Yeah,
the court finds that you owe the court $210. You may make that payment at the court.
Already
Do you
paid.
have any questions about that? All right, then that will be forfeited, and we're done with this case. Thank you very much. That's all for today.
Person, gotcha.
Thank you, Your Honor.
Thank you,
You're welcome.
troopers.
Next matter is the state of Michigan versus James Dash. That's file 25-43580-FY, set for a status review. Mr. Blumberg, is that your case?
Yes, it is, Judge. Thank you. Elliot Blumberg on behalf of Mr. Dash.
Is your client here today? Is he with you?
He's appearing via Zoom.
I do see him now. I just lost him in the shuffle.
Sure.
All right, Mr. Dash is here. Ms. Bruker is here as well. This is a time set for a status review. Do we have a resolution of this matter?
Yes, Judge, I believe we do. After negotiations with the prosecutor's office, my understanding is that counts 1 and 3 of the complaint will be dismissed. Mr. Dash will be pleading no contest to attempted resisting and obstructing. And the reason for the no contest plea is that there is ongoing litigation with the mother of his child arising out of this incident.
So if I can, Elliot, the way the court will structure it is it'll be an added count for attempted resisting the obstructing, and we would dismiss counts 1 through 3.
You know, I wasn't sure how you did it. I thought it was a lesser included in count 2. Whatever, however we need to do it would be fine.
It's just cleaner if we add a count 4 for the paperwork purposes, but I appreciate the information. All right, Mr. Dash, do you understand what the lawyers have said?
Yes, Your Honor.
And is that what you want to do?
Yes, Your Honor.
All right, listen carefully because there are some rights that you would be giving up if you want to do that. And I want to make sure that you can make an informed decision about doing so. Right now, you're charged with 3 counts, which include count 1, attempted home invasion in the 3rd degree, count 2, police officer resisting and obstructing, and count 3, malicious destruction of a building. There would be an added count 4 that would say that you did attempt to resist and obstruct a police officer, being Troopers Kennedy and Trooper Weiner. And then the other 3 counts would be dismissed. Is that your understanding of the agreement?
Yes, Your Honor.
And that you would do this by a no contest plea, which means that you would do that by agreeing to take the consequence, but you would not have to make a statement because there's ongoing litigation. Is that what you understand as well?
Correct, Your Honor.
All right. Right now, you have certain rights, and I want to make sure that you understand those rights before you enter a plea. If you enter a plea today, you'd be giving up the following rights: the right to have a trial by a judge or by a jury, the right to see, hear, and question all the witnesses against you, the right to present your own witnesses and to get an order from the court called a subpoena to require those witnesses to appear and testify. You'd also be giving up your right to testify or your right to remain silent. And if you chose to remain silent at trial, that silence could not be used against you. Also at trial, you'd be giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden remain with the prosecutor at all times. Finally, you'd be giving up your right to appeal automatically from any trial decision. And by entering a plea, you'd be limited to asking the court for permission to appeal. You understand all of those rights?
Yes, Your Honor.
You have any questions about any of those rights?
No, Your Honor.
Knowing all of those rights, is it still your intent to enter a no contest plea to the count 4 attempted resisting and obstructing?
Yes, Your Honor.
All right. I'm going to ask you to raise your right hand so I can swear you in just briefly. You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir. Yes, Your Honor.
All right. Has anybody promised you anything or threatened you in any way to get you to enter this no contest plea?
No, Your Honor.
Are you doing this of your own free choice and free will?
Yes, Your Honor.
All right, Mr. Blumberg, I'm looking for the affidavit of probable cause. Do I have your permission to read that, to use it as for the factual basis?
Yes, Judge, or alternatively, there is a page entitled 0011 that has the written statements by Trooper Wenner that would also provide the court a factual basis. Either of those would be sufficient.
All right, I do not have the police report in the court file. At least I don't believe I do. So let me review the affidavit of probable cause, and I'll let you know if I have any other issues.
Okay.
All right, I do believe that the affidavit of probable cause satisfies the elements of attempted resisting and obstructing, in that it appears that the Michigan State Police, Trooper Kennedy, went to the scene where a person by the name of Rebecca DeGrez was living. Previously, Mr. Dash had lived at the same address, and there was currently a personal protection order pending that forbade him for being at that residence. Trooper arrived, followed him in footprints in the snow leading back through the yard, confronted Mr. Dash, and tried to arrest him, and he pulled away from the officers, tensed up, and resisted the arrest. So from that, and that all occurred on March 15th, 2025 within Otsego County. So I believe I do have a proper factual basis, and I do believe that Mr. Dash entered that plea knowingly, intelligently, and voluntarily. Are counsel aware of any other promises, threats, or inducements that were not placed on the record?
No, Your Honor.
I am not aware of any.
And do you believe that I've complied with the court rule as to plea taking?
Yes, Your Honor.
As do I, yes.
All right, I will accept the plea. Let me make sure I catch up with my paperwork here. Ms. Bruker, given the type of offense, do you believe that we need to have a victim impact statement or an opportunity for the officers to make a statement in court at sentencing?
No, Judge.
All right, Mr. Blumberg, are you asking to proceed directly to sentencing?
Sure, Judge, we could do that. I think it's important that the court ultimately understand the facts behind this whole incident. But yes, we can proceed to sentencing if that's what you think we should do.
I'm happy to give you additional time if you'd like additional time. That's entirely up to you.
James, do you want to proceed to sentencing right now, or do you want?
Yeah, yes,
Okay.
sir.
No, then let's
All
do.
right, that's what we'll do. All right, Mr. Dash, what I'm going to do is I'm going to let each of the attorneys give me their thoughts as to what an appropriate sentence would be. And then I'm going to give you that same opportunity right before I decide what to do with the case. So Ms. Bruker, your thoughts on sentencing?
Just to give the court a summation from the prosecutor's perspective of the facts, officers were dispatched in response to a violation of a personal protection order. On that date, Mr. DeGrez had a valid personal protection order that was still in place. Mr. Dash came to that residence, attempted to enter the residence. When police arrived, he hid himself behind a tree. He would not come out from behind the tree. They had to use some force to place him into handcuffs and to place him in the patrol vehicle. So here we are on that case. I mean, as to those facts. So what I would ask the court to do is to place him on probation. Even though Mr. DeGrez is not a victim on this particular charge, I've had conversations with her, and she's indicated to me concerns about substance use and other factors. So I'd ask that the court, instead of other types of programming that probation could order, I'd ask that the court order that he participate in a substance abuse evaluation and follow the recommendations. I believe there may be a no contact order with her as part of our bond in this case. And if the court is able to, I'd ask that the court continue that no contact order upon her request throughout the duration of probation. And aside from that, I just ask for other standard terms and conditions.
All right, thank you. Mr. Blumberg, your allocution.
Thank you, Judge. There is a long history regarding this case and my client and the mother of his child. Ms. DeGrez is in fact the mother of his child. She was residing in a home owned by my client. She, by virtue of an agreement reached in the custody matter, she was to have vacated that property. She was there well beyond the period that she was allowed. In spite of that, she contacted my client because there was some issues with the power and electricity in the house. The PPO that he was alleged to have violated was to expire the next day. So in spite of the fact that it was in place and at the direction of Mr. DeGrez, he came over he's an electrician by trade. He was going to provide services so that Mr. DeGrez and his son would have power in the house. He knocked on the door, and for whatever reasons, she didn't let him in. She called the police instead. He, not perhaps understanding the gravamen of the situation, did attempt to hide, and he was arrested. The dismissal of most of the counts in this case come about because there's no legal basis for them. He was the owner of the house. He had every right to go enter the house. He couldn't do damage to a home that he owned, so that case, that count was dismissed as well. Mr. Dash has no prior criminal record. This really was about his concerns about his son. And while perhaps he should have waited to the following day while the PPO had expired, he went there based in good faith, trying to provide some services for his child and the mother of his child. I believe that a period of probation, if the court feels it's appropriate, would not need to require any substance abuse counseling. This had nothing to do with alcohol. It had nothing to do with controlled substances. Mr. Grez and Mr. Dash continue to be involved in custody matters, and I believe they're actually even before you at this point. So her concerns at this point is making sure that he doesn't get to see his child. So, Judge, currently Mr. Dash is residing downstate. If the court were to place him on probation, we would respectfully ask the court to allow the probation to be transferred down to Macomb County, where he is currently residing. I think a short period of probation, if any, is appropriate and merely fines and costs. Thank you.
Judge, I don't want to get in a back and forth with Mr. Blumberg, but there are two small factual things about the dates that I could correct if the court would like me to.
Go ahead.
Just the personal protection order was valid through March 19th, and this incident occurred on March 15th, and it was around 3 in the morning when Mr. Dash came to the residence. That's all I wanted to add for context.
All right, thank you. Mr. Dash, you have the right to also address me prior to the imposition of sentence. Is there anything else that you would like me to know?
Yes, Your Honor. I arrived at the home at 3 a.m. because I was been busy moving locations, and it was easier for me to do that at nighttime in the night hours than during the day. When you're moving a shop, there's a lot of materials, there's a lot of stuff, and it's just easier to do at night. Rebecca DeGrez had approached me to come over and, like Mr. Blumberg said, do some work. And when I got to the address, I was confronted by the police. I made a flight response that I regret. And I do agree with what Mr. Elliot Blumberg said. And I do apologize for my actions of going over there 4 days earlier. But I had zero contact with her, and I was only harassed by her during the whole duration of her PPO. And it's been used to elicit my son against me. And that's kind of all I have to say.
All right. Anything else that you want me to be aware of?
I don't believe so, Your Honor. I believe that if I was to, I'm more than happy to pay fees and fines. I don't feel like probation is necessary. I'm 36 years old. I've never been in trouble once. I feel like most of this case is more just a family matter than anything, and I was wronged by her. I feel like I didn't have really criminal intents, and I still don't. And I feel like if there was to be probation, that it should be non-reporting. But at this time in my life, this junction in my life, I'm still a business owner. I still have a ton of responsibility. I have to be all over the state. It would make probation incredibly hard for myself. And I don't feel as if that should be even a consequence to these actions. I feel like not seeing my son for over 2 years has hurt me more than anything that a court system could inflict on me.
All right. Thank you, Mr. Dash. Your attorney asked if the probation could be transferred down to Macomb County. I don't think that's going to be necessary. Typically, most probation interviews or contacts is via Zoom and video. So I think wherever you're living at, you'll be able to report with and discuss the matters with your probation officer here. I'll leave that to her discretion. However, typically I wouldn't be granting that request up front. The other general comment that I'm going to make before I become specific about what your sentence is that it appears to me that you've got some decision-making problems. I get it that you could have a fight or flight response when first confronted with the police, which would cause you to hide behind a tree. But once they find you and tell you that they're going to put you under arrest, fighting with the police just exacerbates the problem. And it's one of the reasons, one of the largest reasons I'm going to put you on probation. Because if you're making a decision to fight with the police, then we certainly need to monitor your behavior because you're not making good decisions at that time. The other thing that bothers me is that you're at your house, at your ex-wife's or your mother of your child at 3 o'clock in the morning. I don't care who you are, whose house it is. You don't come to anybody's house at 3 o'clock in the morning without asking for permission first, whether you own the house or not. If somebody else is living there, whether you think it's right for them to live there or not, you don't come to anybody's house at 3 o'clock in the morning.
Your Honor,
That's just not, this is not your time to talk. This is my time. Okay. 3 o'clock in the morning is not normal business hours. It's not even closely related to normal business hours. You just don't show up. That's just common sense. And if you're not able to make that level of decision making, then the court's going to need to monitor your decision making to
Your
make
Honor,
sure
I
that
need
it
to say
is
something.
appropriate.
James, stop.
This is, I know you want to explain your behavior, but it's too late for that.
No, I was invited over for sexual intercourse.
You're not making it any better, Mr. Dash.
Well,
Do what
that's
your
why I was there
attorney
at 3 a.m. if we're
do
talking
what
about
your
why I was
attorney
there at 3
advises you to
a.m.
do and keep your mouth shut, sir.
Okay.
All right. I'm going to put you on probation for 180 days. There'll be a probation oversight fee of $180 for that. There's a crime victim fee of $75, a justice assessment of $50, court costs of $300, a fine of $150, and a local charge of $15. Let me add that up for you. It's a total of $770. You can pay that off over the course of your probation. You may perform community service work in lieu of some of those fines and costs at the discretion of the probation department. I am not going to impose substance abuse or drug screens on you because there doesn't appear to be any credible information at this point that you did that. But again, your decision making bothers me. I am going to continue the no contact. You may not associate with Rebecca DeGrez. Unless in compliance with a custody order. So if there's an outstanding custody or parenting time order, or if there's one in the future that's being done, you may have contact with her only for the limited purposes of custody and parenting time as that other order requires. There will be no assaultive, abusive, intimidating, or threatening behavior because of the nature of the allegations of your behavior with the police officers. Are you working downstate, sir?
Yeah, I'm working in Romulus.
You work Monday through Friday schedule?
Yes, sir. Yes, Your Honor.
40 hours a week?
Plus.
Ms. Hill, are you with us from the probation department?
She's
gone already?
Yep.
All right. I'm going to require you to enroll or have an assessment done to see whether you should enroll in an anger management class. I'll leave it to Mr. Blumberg to assist you in finding how to do that. The reason I was going to contact Ms. Hill was she's the probation officer here. She may have some ability to help Mr. Blumberg find one of those or find out how to get assessed for that. But I'll leave that to your counsel. If you are assessed to qualify for that anger management class, you must enroll if recommended and follow all recommendations. That is what type of class and how long it's going to last for and what you have to do because of that class. All right, that will be the order of the court. Any questions that you have, Mr. Dash?
No, Your Honor.
Mr. Blumberg, anything?
No, Judge, thank you.
Ms. Brooker?
No, Your Honor.
All right, that's all for today then. Thank you very much.
Good morning, sir.
Good morning.
Are you John Wadley?
Oh, yes, sir.
This is Judge Middleton. We've met, but I needed to talk to you this morning. Mr. Keith Stickley, the Chief Public Defender, is here. And also Mr. Josh Robert, the Chief Assistant Prosecuting Attorney, is here as well. You got arrested last night for failing to appear for a probation violation arraignment. Where did you get arrested?
Oh, my mom's.
In Michigan Avenue?
Yes, sir.
They came specifically to get you?
He pulled up. I was working on my wife's car, and I pulled out, and then I turned around right by him. He was parked on the side of the road. I turned around right there and pulled back in, and I showed him the oil where it was leaking, and I was trying to fix the car. I was going to appear. I tried to get a hold of Miss Davis about my kids. I just found out I had 2 kids, and one's racist, and the other one is mixed, and I got caught in between the 2 of them.
All right. Well, Mr. Bush was your lawyer on this, and your probation officer was Autumn. So let's talk about this. You've been off the radar. You've had a rough couple of years. If we go way back.
Sorry, I didn't even know I had.
Resisting and obstructing and domestic assault. 2020, assault with a dangerous weapon, 3 counts, and resisting, obstructing. And then this count started, hold it. Started as assault with intent to do great bodily harm, domestic violence, second offense, 3 counts. You entered a plea to domestic violence, second. 2 counts, and I put you on probation. I gave you 62 days and deferred 60 back last May. And then you went off the grid. So I did a bench warrant for you last October. I haven't seen you since. Let me talk about the actual petition. I'd like to ask you a bunch of questions, but your lawyer isn't here. You were struggling with methamphetamine. You were connected to CMH, and then we just lost track of you. The allegation is that you failed to abstain from the use of drugs and alcohol, and then failed to appear for your probation violation in October. I have 60 days of jail hanging over your head, which is likely to be imposed with your issues. I don't know where you've been. You've been just hanging around waiting to get arrested, I guess. But at least the good news is you won't have to look over your shoulder for a warrant anymore. I'm going to show a plea of not guilty. I'm going to appoint an attorney, set a PV hearing. You have a history of assaultive behavior, and you didn't show up, and you just been under the radar.
And that rage baiting, they set me up for that domestic. That was wrong. I got a detective on this that's working on this from the FBI. I'm serious. I'm not playing with this no more. I didn't even know I had kids. These guys are really wrong doing this to me.
Well, you did this to yourself. You just quit showing up. You quit going to your treatment. You quit reporting to your probation officer, and you just got arrested. So like I said, we're going to resolve this. But I'm sorry, go ahead.
I'm still doing my treatment. I didn't know I had kids, Your Honor. I know that's no excuse. I should have still came in. I had no clue.
Didn't know you had kids.
Yeah, I got kids. I had no clue I had. They got into a fight. I tried to break it up. I got one kid that's racist and I got one kid that's mixed. I didn't even know I had.
All right, well, that's no reason to not show up for 8 months. So we'll get it back on track. Your bond's canceled. You're gonna sit there until we resolve this. Mr. Bush or another attorney will be represented to you. I'll let Autumn know you got picked up. Sounds like you're having either some mental health issues or a meth crash or both. So
No, I got my toes rotten. My toes rotting. I need to get my toe looked at. I gotta get to a hospital. It's the woman said it looked like gangrene. You can see the bone. It's bad.
all right, we'll have the jail nurse take a look at that. We'll get at this sooner rather than later because I'm gonna be leaving on vacation and I don't want to make you wait for several weeks. So it'll probably be sometime next week. All right, sir. Morning, sir. You Aaron Anthony Smith?
Yes.
Mr. Smith, you're here with your lawyer, Mr. Luke Knopfinger. You got charged with some serious charges. It's alleged that on April 1st of this year, you made an assault upon Josh Wired with a dangerous weapon, a BB gun, and on Garrett Buglione with a BB gun. Those are both police officers with Sturgis Police Department. And Adam Kreitz, which is also a police officer. More than a few times, someone's been shot by brandishing a BB gun to an armed police officer. It's a very dangerous circumstance. And they charge you with malicious destruction of a car that belonged to Austin Mitchell. Those are all felonies. The first three are felonies. The last one's a misdemeanor, punishable by less than $200. You do have a right to have the hearing within 14 days of your arraignment. But you've agreed to adjourn this for 7 days and have the matter rescheduled for next Tuesday morning. Is that correct?
Yes, Judge.
What's the reason?
Some more fact finding here, Judge.
You indicated his guardian is here, also here.
Yes, Judge. She's in the gallery.
That's you. Thank you for being here. How long has he had a guardian?
Several years, probably since he turned 18.
How old are you now, sir?
32.
Take a look at your bond conditions. It is a condition of your bond that you have no weapons, including BB guns or rifles, no assaultive or threatening behavior, must remain with the guardian at 506 South Jefferson Street, must comply with current order from probate court, and you're signed with pretrial supervision. This bond was set by Judge Pattison with some care. So your bond conditions are continued. Are you still connected with services at Pivotal?
Yes, Judge. He's on the ACT team.
All right. This is gonna switch this, I think, to Judge Pattison's calendar, but he does seem to have knowledge of it. So I'm gonna set pre-exam for next Tuesday, which would be July 8th. Well, that might be my day anyway, I'm not sure. At 8:30. And a preliminary examination if needed for July 15th at 1. Bond conditions remain in effect. All right, Mr. Smith, stay in contact with your lawyer. and your guardian, comply with all the terms of your bond. And either me or Judge Pattis will see you next Tuesday morning. You're good to go, sir. Danielle McNeese is charged with possession of methamphetamine. Oh, she is here. Very good.
Your Honor, does Mr. Nussinger have a few to do? Or-
This is the last one.
Oh, okay, because I know I'm get upstairs too at 9, so.
What have you got up there?
I've got a whole series of status conferences that got
Oh, let's
reset.
finish your stuff here first. We'll get you out of here by 9:20, depending on how long Luke talks. Depending on how long I talk. Good morning. Are you Danielle McNeese?
Yes,
You never contacted your lawyer while you're on bond?
I did not.
Why
And I'm
not?
getting a phone today. I didn't have, my phone got burnt in a fire.
What are we gonna do with this one, Luke?
Judge, we were able to connect this morning and she's prepared to enter a misdemeanor plea.
To use of a controlled substance?
Yes, Judge.
Is that correct, Mr. Robert?
Yes, Your Honor.
Well, Ms. McNeese, let's talk about this a little bit. You're charged with possession of methamphetamine, which is unfortunately a very common offense. It's punishable by up to 10 years in prison and a fine of up to $15,000. You're charged as a second or subsequent offense, which makes it a 20-year, $30,000 type offense. I don't think anybody ever got 20 years for this, but that is the maximum. Prosecutors agreed to dismiss the felony charges for a plea to a misdemeanor of use of methamphetamine. Use of methamphetamine is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. You're not eligible for 7411 probation, but I could put you on probation. I don't know too much about this. So my intention, if you do enter a plea of guilty to this, is to set it for sentencing to get more information before I do the sentence. Do you understand?
Yeah.
Other than this plea agreement here, did anyone promise you anything to get you to plead to this?
No.
Or threaten you?
No.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury? There will be no trial. Do you understand that?
Yes, I do.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Nussinger has been appointed, and you did come today, which complies with the terms of your bond. You could also hire an attorney of your own choosing if you wish. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to, because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you also signed the waiver of rights. All right, let's talk about this. It says, while they were conducting a traffic stop way back a year ago, July of 2024, they stopped you and they found a baggie of something which they tested and came back as methamphetamine. Is that correct?
Yeah.
Sent to the lab. And they didn't authorize this till December. So this happened in mid-July. They sent it to the lab. Takes a while for that to happen. And then when did you get arrested? I can tell
Like
here.
2 weeks ago.
Well, you got arrested on July 15th. They let you out. And then you got rearrested June 19th. How'd they pick you up in June?
That there was a fire, a tent fire, and they came down there.
A tent fire?
And I was down there, yeah.
Where was that?
Over on by Charles Street in Kalamazoo. I went down there to visit one of my friends and my daughter, and somebody's tent caught on fire.
And then they ran everybody and found this warrant for your arrest?
I told them as soon as
Okay.
they.
And your phone got burned up in that fire?
Yes.
Are you on probation or parole anywhere else?
No.
Not Kalamazoo or anywhere?
No.
Are you on bond anywhere?
No, only here.
I show a Edward Street address. Is that correct, or are you sort of between, are you homeless right now?
Yeah.
Homeless? What they say, unhoused? What you got here? If I gave you a test today, what would be in it?
No.
Nothing? No marijuana, no methamphetamine, no opioids?
No.
All right, well, I'm gonna give you one at some point. Autumn, can you come up and help me? I'm not gonna sentence you today, but I wanna know what I'm dealing with. My suspicion is you're still struggling with methamphetamine. And if you are, you might as well just tell me. I'm not gonna lock you up, but I am gonna, at least not today. So you'd be negative for methamphetamine today?
I haven't used in almost 3 weeks to a month.
All right.
I'm trying to get into a rehab center there, right there in Kalamazoo.
Have you heard of Bear River?
No, I haven't.
It's up north, Point City. I'm gonna give you a test right now, but I'm gonna set this for sentencing a little bit. If you could get into a residential treatment center, that would be good. Have you done treatment before?
No, I have not.
When you got your earlier conviction, they didn't order any treatment or anything?
No.
Monday, August 11th at 10:30. Does that work for you?
Yes, Judge.
Would you take Autumn and her back? We're gonna just do a urine test right now and see what's in there. Sentence. August 11 to 2. All right. Rhonda, do you have anybody that's here live to address?
Mr. Brooks is in the courtroom. He signed his waiver.
Okay. Mr. Brooks, would you come forward? Good morning, sir. Good morning. Rhonda, I did discuss sobriety court. I don't know whether it's an option here or not, but could it even be explored if it's a felony case? We've got several felon referrals to sobriety court, so that's just something for everybody to consider. It is not excluded, even if he is a felony. Some of our most successful people recently have been convicted of a felony charge. But Mr. Brooks, I just want to remind you of your bond conditions. No drugs and no alcohol. That's a common condition. No firearms, no assaultive behavior. You're not under pretrial supervision. You're not testing anywhere, which is not ideal. Are you still living on M60?
No, I live at the motel area.
Okay. All right. Are you working someplace?
Yes, I work at Closer.
I think you told me. All right, so you got a good job, but alcohol has been on your tail for a while. Are you doing any meetings or anything?
I'm working on trying to do something like this.
No, don't be working on it. Do it. All right, your matter's bound over to circuit court. It'll be under the supervision of Judge Stutzman. Continue to comply with the terms of your bond. My recommendation would be you get into some treatment. One option is a long jail sentence for Judge Stutzman. Another option is whether treatment or sobriety court would be an option. So if you're just going to sit around and not do anything, you might as well just put you in jail. So if you want to impress him, start doing something now before you get there for your case. All right. You're good to go, sir.
Yep, I'll let you know when your registering date is. I'll call my office so you can bring up on driving and we'll put everything else on driving. Okay, just look it up on driving.
All right, we have a waiver in Casey Willis.
What's that?
How'd we do, Autumn?
We're positive from that.
Well, that was my guess. Miss McNeese, would you come back up? I'm gonna set your sentence for August 11th at 10:30. I'll give you this because you might not have mail. You're still struggling with methamphetamine and you're not being honest with me or yourself. So you're positive today. I'm going to test you again when I see you on August 11th. You're talking about getting into some residential treatment. I want you to follow up on that and we'll hear more about it on August 11th. One option is to give you some treatment by starting with a jail sentence of 30 to 60 to 90 days to help get your system detoxed. So I want to know what you're going to do between now and August 11th, but all right.
It's the gray stone.
All right. Well, you stay in contact with your lawyer. Do you have a phone now?
I'm getting a phone today. I'm actually picking it up when I leave here.
All right, well, make sure he's got your number. All right, you're good to go. Thank you, Autumn.
Thank you.
Good morning, sir.
Good morning.
This is Judge Middleton. I'm here at the courthouse. Your lawyer, Rhonda Ives, is here with me at the court. Also is Chief Assistant Prosecuting Attorney Joshua Robert. Mr. Cisco, this is the time and date for your pre-exam conference. You're charged with a felony offense. Let me recap that.
Yeah.
It's alleged that on or about April 2nd that you assaulted Matthew Borman, Brian Stuck, and Aaron Moore of the Three Rivers Police Department. Excuse me, Sturgis Police Department. Those are felonies punishable by up to 2 years imprisonment. You're alleged to be a fourth habitual offense, which I think would make these a maximum of 15 years in prison, which is a lot. So 3 counts of R&O as a fourth habitual offender. Mr. Robert has agreed to dismiss those charges for a plea of no contest. We'll talk about that in a minute. To 2 counts of attempting to resist or obstruct a police officer. Attempting to resist or obstruct a police officer is a misdemeanor. It's punishable by up to 1 year in jail and a fine of up to $1,000. I think you've been in jail since the 2nd of April. Ms. Ives, is that your understanding of the plea agreement?
Yes, Your Honor.
Mr. Robert?
That's correct.
Mr. Cisco, by pleading no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. You've been having some mental health struggles, and you've had a competency evaluation. You've been determined by the Center for Forensic Psychiatry and Judge Pattison to be competent. So I'm here today to take this plea of no contest to 2 counts of resisting, obstructing a police officer. Now, by pleading no contest, I'll use a other source of information, in this case, a bond report filed by Officer Borman as the factual basis. Is that acceptable to you?
Yes, Your Honor.
All right, you seem real good today, and that's encouraging. Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or jury, and there will not be a trial? Do you understand that?
Yes, Your Honor.
If you had a trial, you'd have the right to be represented by an attorney. Ms. Ives is here with me. You also could hire an attorney of your own choosing if you wished. If you did have a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand all that?
Yes, Your Honor.
And your plea here is of no contest to 2 counts. We'll do Officer Borman and Officer Stuck. Is that agreeable?
Yes, Your Honor.
All right, according to the bond information report, this started out sort of innocently enough. April 2nd, they get called to the library because somebody was sleeping there in a common area of the library. And they'd had some dealings with you before, once had a knife, and said, well, you can't just sleep at the library. You had your hands tucked in your sweatshirt, and they had that recent incident with a knife. Said, don't touch me. And then they had to struggle with you at the library and get you out of there. He did not have a knife. He also stepped on Sergeant Moore's foot. So not the worst R&O that I've seen. You've been in jail for 90 days. Mr. O'Bear, what's your thought?
Seems like he's in a better place now mentally than he was when this case began.
I agree with that. He seems much better today.
Had a lengthy jail sentence. So not looking for anything additional.
Mr. Cisco, where are you going to go if I let you out?
Back home to my dad to 127 South Meadow.
All right, Ms. Ives, you got anything to add?
Well, he said that his job, he still has a job available for at ACM, so he's hoping to get out and get back to work. He has also indicated, he's willing to follow up with his mental health treatment so he doesn't end up in this situation again. And he sounds like he knows what he needs to do. So hopefully he can do it and not have further difficulty.
Are you on any medication now?
I'm not, Your Honor. The only thing I'm supposed to be on is Invega.
All right, this was not the worst R&O. You just sort of struggled with them because you were sleeping in the library because you were half a step from homeless. I'm gonna give you 90 days jail credit, 90 days. There's no reason to hold you in the jail further. You went through a whole course of treatment at the Center for Forensic Psychiatry. I'm not gonna do a probation. However, if you end up doing this again, it was this earlier incident with the knife, you're just gonna end up back in jail. Fine is $0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee. That's $275. Make that due by October 1st. I'm going to give you some time to get out on your feet, but you got a place to live back at your dad's. You've been in jail for 90 days. You've been through a course of treatment at the Forensic Center. It wasn't all that serious of an incident. You've accepted responsibility. and you're gonna get out of jail here this morning. Will somebody come pick you up?
I will be walking, Your Honor, but I'm okay with that.
All right, well, it's hot, so if you need a bus pass, you just come up here to the courthouse and ask the bailiffs out at front, and they'll give you a bus pass. I've got some generous people that donate bus passes for us to use here at the courthouse. So if you want to get a ride, walk up to the courthouse.
Because I also have to go to DA, because the day, April 1st, my wallet got stolen, so.
All right, well, the offer's open. If you want a bus pass, you come up here to the courthouse and the guards at the front will give you one.
Okay, Your Honor, thank you. I appreciate that.
All right, you're good to go. Thank you, sir. Good luck to you.
Good luck, Craig.
Yeah, thank you.
All right, does that finish your obligations, Rhonda?
It does, Your Honor. Thank you.
All right, I was 8 minutes longer than what I said, but give Judge
Okay.
Stutzman my apologies, and you've got a waiver coming for me on one more. Brianne McRoberts. Good morning. Are you Brianne Lynn McRoberts?
Yes.
You've got one case set for today of dangerous weapon and no insurance. And no, yeah, that's set for pre-exam today. That's file number 23513FY. It's 2 years old. Then you got a resisting obstructing from June 18th. So my guess is when they picked you up on this old warrant resulted in this new charge. And that also has a no operator's license. And that is set for today also. Luke Knopfinger is your lawyer. He's here. Also present is Mr. Joshua Robert from the prosecutor's office. Mr. Robert, what's the status here?
So there's an offer that would encompass all three of her files to plead to one count of attempt R&O and 251158FY, no insurance in 23-513FY with forfeiture of the knuckles, and no license in 251159ST.
All right, Ms. McRoberts, there's a lot going on here. Let's break this down. Way back in February of 23, you got pulled over for no insurance. And you had a pair of brass knuckles in your possession. A lot of people don't know that, but possession of brass knuckles in a vehicle in Michigan is a felony. In fact, I think just possessing them is a felony if they're concealed. They're offering to dismiss that charge and forfeit the brass knuckles. And you're going to plead to operating a vehicle without any insurance. That's a misdemeanor. It's punishable by up to a year in jail and a fine of not less than $200, not more than $500. Do you understand that charge?
Yes.
You're also going to plead to operating without a valid operator's license on June 18th. So let's segue to the next case. They pull you over on June 18th for no license. That's a misdemeanor. It's punishable by up to 90 days in jail, fine of up to $100, carries 2 points, but does not require a suspension. Do you understand that charge?
Yes.
And then there was also some sort of scuffle with police officers, which is a felony charge. That's punishable by up to 2 years imprisonment and a fine of up to $2,000. The misdemeanor is attempted resisting and obstructing. That's punishable by up to a year in jail and a fine of up to $1,000. So you're going to plead to attempting to resist the police officers on June 18th and driving without a valid license on June 18th. Is that correct?
Yes.
You've also signed the advice of rights. Thank you, Luke. And you've heard me go through them a couple of times, so I understand you're giving those rights up.
Yes,
All right, on that day you were driving, did you not have a valid license?
on the 18th,
Yes,
I had my permit.
but you didn't have a licensed driver in the car?
Correct.
All right. Then, let's see. They had this old warrant for that or that brass knuckles. They ordered you to get out of the vehicle, you didn't want to get out. And they had to pull you out of the vehicle. Tell me what happened once they stopped you for this.
The officer comes up to the window and tries to open my door and doesn't tell me why he's pulling me over, and I ask him why. And then he puts his hand inside my car and tells me to get the F out. He had a hold of my arm. I jerked it back and said no, and he tased me and drug me out of my car. I just wanted to know why I was getting pulled over. And he said he didn't have to tell me.
Hank, McRoberts advised she knew she was being pulled over by a police car. Is there a video of this?
There's his body cam.
All right, maybe we'll take a look at that. All right, so eventually you got out and then they arrested you. All right, then let's talk about the brass knuckles incident. On that day back in February of 23, were you driving a car without insurance?
My boyfriend was.
Well, let's look at that one. Was it your car?
Yeah, I had just bought it 2 days prior from getting pulled over.
All right, admitted that there was no insurance on the vehicle. Brianna admitted the vehicle did belong to her. Plus, they also impounded it. How much was that?
I don't know. I never got a hold of him.
So the car got impounded and they just kept it?
Yeah.
What was it?
A big blue Dodge Durango. I bought it in Elkhart.
Why did you have these brass knuckles?
My sister-in-law gave them to me,
All right, well, she didn't.
and I was homeless at the time.
What's your circumstance now?
What do you mean?
Are you living on Riverside Drive in Constantine?
No, I'm staying with a friend at 207 Susan Street in Sturgis.
Your brother's here with you today?
Yes, my little brother.
All right, well, that's good to have family to help you. Are you employed?
Not at the time. I'm a stay-at-home mom.
How many kids?
I got one child. She'll be 5 in September.
Well, this is a lot to unpack here. I think I'm gonna set this for sentence. Luke, did I just set you for August 11th?
Yes, Judge, at 10:30.
I'll set for August 11th at 11. I'd like to get the police report and videos if possible. This all started as a no insurance, which ain't exactly the crime of the century. And then there were the brass knuckles. Then I don't know what happened. They requested a warrant. And then when they see a warrant for a dangerous weapon, it puts the cops on alert. So they're arresting you on an open warrant for a dangerous weapon. Probably isn't clear what it was. So already they're being super careful. You didn't want to get out of the car. It all went downhill from there. Being tased doesn't sound like much fun. So I'm going to see if I can watch the video to see what they said to you and you said to them, get the police report. Do you have insurance now?
It's my dad's car.
Well, you lost it. So I'm not going to do much on that, but it carries a minimum $200 fine. I'm going to set all cases. Does your lawyer have your number?
He has my grandma's number.
All right, so he knows how to get a hold of you?
Yes, sir.
When did you last work?
4 months ago.
Where was that?
The Indian Camp of Nazarene.
in Vicksburg.
Are you on probation or parole anywhere else?
No, sir.
Do you have any charges pending anywhere else?
No, sir.
All right. All right, let me see if I can get the police reports, the videos, get more information about this. I don't want to just shoot from the hip. You seem like a nice girl that got sideways a couple different ways. I'll see you on Monday, August 11th. All right, you're good to go.
Thank you.
Is that everything? It is? 2 o'clock, we gotta come back and do this tomorrow? Who's gonna be here? Miss Lowe gonna be here? Oh, she didn't have any cases. She's traumatized. All right, what? I'm being mean again? Okay. No, you haven't seen me. I can really, never mind. Probably shouldn't say it on the record. Court will stand in recess. All right. Court does call the case, People versus Leon McEwen.
And that goes for the people?
Yes, Your Honor. Brandon Bird on behalf of Leon McEwen. Mr. McEwen, can you please step to the podium? Oh, there we go. State your full name for the record.
Yeah, McEwen. Thank you, sir. What are we doing?
I'd like to.
For an adjournment?
No, Your Honor. We'd like to set this matter for exam.
Okay. Yes, sir. Discovery is complete.
It is, Your Honor.
People have their witnesses available to 15. Preliminary examination in person will be set July 15th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you.
Hang on a second. Is there a bond? I don't have one. Is there one? Hang on a second. I don't know if we have a violation report.
I believe I received that today, Your Honor.
You did? I don't have. Is she here? You knew I was going to ask you. You're printing it today. Okay. All right. Anything you want to say regarding this violations?
First of all, we'd like to apologize to the court and the prosecution for making representations that my client was clean. I just received a report today and I was going off the indications of my client, in which he apologized to me. And he wants to apologize to this court.
Well, but here's I mean, I understand the apology, but he had, by telling you what he told you, he had you give certain representations to this court.
And believe me, we had a long discussion about that.
I'm sure you did.
We did. I believe my client maybe was embarrassed. I did, after discussing this with my client indicates to him that he did relapse. The stress of this case was helping him relapse, but he said one thing that really mattered. He said, it's not an excuse. And I understand that my client is taking accountability for this situation.
So he admits to this violation.
He admits to it, Your Honor.
All right, go ahead.
I believe my client takes accountability for this situation. He really came to me and said, I'm really trying to straighten out. He understands that he needs help straightening out, I understand that addiction is more of a disease, and I believe there's better ways that addiction could be handled besides being in the confines of the county jail. My client will take, he is trying to take some conditions serious, Your Honor, but my client suffers from an addiction. He suffers from that disease, and he understands that he needs that help. And he actually indicates to me that he reached out and has been searching for help. He could tell you, I know Domino Farms was one of the places, correct?
Yes, sir.
And he was telling me other aspects, other avenues that he was looking at to get that help. We just asked that this court have leniency, and we're coming to beg your mercy on this matter, and ask that this court have leniency on my client, maybe even allow him in an inpatient treatment, Your Honor, instead of having them behind bars.
Anything from the people?
Your Honor, as the court may remember, yes, last time we were here, we were going to set it for exam, and I had put the offer on the record that it was that if Mr. McEwen provided proof that he had undergone some treatment since the date of this offense, that he offered that misdemeanor, and Mr. McEwen had interrupted and said he'd been in treatment for 5 years. Mr. Bird later, we adjourned, and Mr. Bird later came to me to tell me what the proof was, and while I respect that Mr. McEwen represents that he was for some time clean, I believe that he needs some help from some sort of a program, and so I do not think at this time that he is able to comply with the bond conditions if he's not in a program.
Anything else you want to say?
I respectfully, Honor, I'm asking if there's any way possible that my client, if he does go to jail today, could he be released to some sort of inpatient treatment?
I will always sign an order that allows him to be released to treatment, but what he's not going to do is come before this court, violate our bond conditions, then lie to counsel, have that lie, then go to the court and think that somehow or another he's going to get over on the system. It doesn't work that way, and it certainly doesn't work that way with me. All right, because I know that if his circumstance, if he had told you the truth, Mr. Bird, you would have made sure to try to communicate in some way to this court. Not only just in terms of your ethical obligations, but also just in terms of trying to make sure that the right thing gets done, because that's the way that you are. So I think he's let down a whole lot of people, most of all himself. So at this time, certainly I will entertain anything, but is to go before Judge Washington on the 15th, but in the interim, defendant's bond is revoked. He's remanded. Court calls the case. People versus Aaron Fromm. Oh, he's here. They're both in Zoom. Okay, counsel, I can't hear a word you're saying.
Is it better now?
Oh, we could say something again.
Sherilyn Foster Tucker on behalf of Aaron Fromm.
Yep, we got you now. Okay. All right.
Your Honor, I was going to say that defense counsel brought to my attention that Mr. Fromm actually had a case in Wayne County that covers the same allegations, and so I'll be filing a nolle prosecution.
All right. Any objection to that?
No objection, Your Honor.
All right. This case is dismissed. Once it comes across, I'll sign off on it.
Thank you, Your Honor.
Thank you. Thank you, Mr. Fromm. Court does call the case People versus Anjane Yancey.
Good. Hello, Your Honor. This is Anjane Yancey.
Hello.
I don't know if you can see me.
Yes, we can see you.
Okay. Good afternoon, Your Honor. Gabriel Lacey for Miss Yancey.
I can't see you, Lacey. No, I'm kidding. All right. All right, what are we doing in this case?
Yeah, I don't know if you would be willing to go into a quick breakout room with me and the prosecutor.
Okay, that really causes problems because then I got to move since you're on Zoom.
Oh, yeah, okay. I hear what you're saying.
I mean,
Yeah.
I can do it. If you think it's that important, I can do it.
I can put it on.
I'd have to pass it because I'd like to get one more case out of the way. But if you think it's necessary, I'll do it.
Okay, I don't mind you passing.
All right.
Thank you, Your Honor.
Pass this case. All right, thank you. Let me get this one out of the way. Court does call the case of the People State of Michigan versus Charles Hudson.
Laura Willenbring on behalf of the people.
Oh, you're muted, counsel.
Okay. Good afternoon, Your Honor, again. Nicole Blank Becker, sorry, Judge. It's been a long day. On behalf of my client, Mr. Charles Hudson, who is currently here now via Zoom. Thank you, Your Honor. We're ready to proceed.
All right. Sir, state your name, please.
Charles Hudson, sir.
All right. And counsel's requesting a forensic examination regarding competency. Is that correct?
Yes, Your Honor.
All right. And counsel, I apologize, but I just don't do them by stipulation.
No problem.
Okay. So I have signed the order and then we'll set a competency hearing date for October 2nd, 2025, 9 a.m. We are, so the council's aware, that's pretty much that period in time. We are getting some back quickly.
Great.
For whatever the reason is. So if it does come back, we will notify the parties and set a hearing date in court with statute.
Perfect. Thank you, Your Honor.
All right. Thank you.
Have a good holiday, everyone.
All right. Everybody do the same.
Thank you. Judge, do you have the ability to put me in a breakout room with my client?
With him? Yes, I have that ability. Would you like us to do that?
That would be great.
I usually don't, but I will.
Because I'm the last one.
No,
Oh, no, there's
because
another one.
because you're my favorite. That's why.
Of
No, I'm
course
kidding.
I am.
All
Thank
right.
you, Judge. I really appreciate
No, we'll
it.
make it happen.
Okay,
And
great.
we can
Thank
do
you.
that. All right.
Appreciate you.
There we go. Okay, court does call the case of the People State of Michigan versus Yancey.
That is for the people.
Good afternoon again, Your Honor. April Lacy.
Good afternoon, Your Honor. Andy.
All right. Okay, what we will do in this case, record to reflect we had a bench conference in this matter. Discovery is complete, correct, Ms. Lacy?
Yes, that is correct.
And would the people be able to have their witnesses available on the 22nd? All right. So I will set preliminary examination in this matter in person for July 22nd, 2025, 12 noon before me.
Thank you, Your Honor. Thank you.
Thank you.
Oh, let's see here. I think that leads us to this point. Where, ladies and gentlemen, I say thank you for coming out. I'm Lone Wolf Usul. This has been a Saturday weekend review. And we are done. I hope you had fun. Those are some interesting cases from this past week. There's a lot that could be said about them. Nothing that I'm going to say right now. Comment. Let's talk about it in the comments. Like, subscribe, do all the stuff. Come by every night of the week around, I don't know, 9 o'clock Eastern time. We have these live chats with a premiere every night, looking at the docket of the day. It's fun. Can't really say enough about it. The people in the chat are amazing. So come by and hang out with us. Until then, keep an eye on the channel because I've got lots more videos to make, and I'll be putting some together, and you'll be seeing some more for Monday evening. I have a good feeling. I don't know. We'll see how it goes. Ladies and gentlemen, thank you very much for hanging out with me today. It's been a pleasure being your host here at the Weekend Review. It is a pleasure to be your curator at the Court Gallery. I am your Lone Wolf Usul. I will see you here every weekend, Saturday, same time, same Wolf channel. Oh my goodness, Kat, I see this and I'm not going to ignore it. Thank you so very much. Thank everybody. I think I got more than the super chats were awesome today. Thank you very much, Sally Port, for your super chat much earlier. I didn't pause the stream to say anything about that because it's just not like this channel's deal. But hey, thank you very much for that super chat. That was fun. And Kat, thank you very much for the sticker. The stickers are always a blast. So, ladies and gentlemen, I'm pretty sure getting to the time, the song's gonna run out. And I'm gonna say, y'all have a great Saturday afternoon. I'm gonna wrap it up here. I'm your Lone Wolf Usul. I will see you next time. I'm out. You're all awesome. Just great. Just the bee's knees. That's all there is to it.